Good. My name is Nathan Renov. I'm a patent attorney at Procone. Full name is Procone Tzedek Latzer Baratz. Go by Procone, it's easier. It's a tech-centric full-service firm in New York with offices in Tel Aviv. I work out of the New York office in Times Square, offices in Tel Aviv, Boston, Los Angeles, London. I specialize in patent law, helping people draft and get patents to protect all different types of things, particularly in the tech space. But I advise on all types of intellectual property, and I find our firm handles all the ancillary legal issues that tech clients would need. I work a lot with startups, and I find that startups typically just don't know, startups and small businesses typically just don't know enough about what they should know in order to protect their business. And so I tend to speak a lot about this issue because there's sort of fundamentals that every small business and startup should know in order that all your efforts don't get wasted by somebody else essentially stealing what you've created. So I'll run through some of those, the major points, and then we'll get into some of the details. The four major types of intellectual property are patents, trade secrets, trademarks, and copyrights. There are others as trade dress and some other things like that. People tend to have a baseline understanding of these things, but I also find that people confuse them a lot. People ask me if they can patent their logo or trademark their software, so hopefully we can clarify some of these issues. Just briefly, patents really protect innovation. Trade secrets are important information that is proprietary to the business that gives you a competitive advantage. Trademarks are really about being a source identifier, as we'll talk about. It's so that people know where the product or service is coming from. And copyrights really protect original works of authorship, whether it's a book, a song, code that somebody wrote, and the like. But actually, before you, for any startup or small business, before you jump into investing in one of these or any of these things, it's important to take initial steps just to know where you're holding, essentially, when it comes to your intellectual property. So an IP audit is basically just going through what you have, speaking to an intellectual property attorney, thinking about whether you have trademarks or something that's trademarkable, something that's protectable, if you have an innovation, an invention, something that's protectable with patents, or trade secrets, things like that. Doing research is always a good idea. Know your competitors, know what you're investing in before you get involved with it, and know what the intellectual property landscape is. And occasionally, competitors already have intellectual property, and you need to navigate that, which could include getting licenses from other companies. Maybe you're using somebody else's technology and implementing it in a new way in your technology or in your business, but you need to get licenses for the ability to use that intellectual property. You have defensive and offensive intellectual property, right? There's protecting the innovations that you have so that you can make sure that if you need to stop somebody else from infringing on what you've created, you have those things in place, be it copyrights for code, for example, or patents. And then you have also, from a defensive standpoint, you want to make sure that if anybody else would be coming at you, that you have, like I said, the proper licenses, that you know what the landscape of the intellectual property is, so that you know whether you're infringing other people, whether you're using a trademark, for example, that somebody else in the same domain is using. You want to know about those things, and having your own intellectual property can help to buffer against that. So getting more specifically into some of the details, a patent is essentially an exclusive right that's that has to be granted to an inventor or a company that purchases that has assigned that invention, that basically grants you the exclusive right. It's actually not a right to do anything, but it's to exclude others from making, selling, or using, importing your invention. And the reason there's an important but subtle distinction there, you may have a patent on something, but that may actually not allow you on its own to practice whatever you have patented, because your patent may rely on somebody else's technology, which itself may be patented. For example, a basic example, if I'm the first person that ever thought to add an eraser to a pencil, so I may have a patent on the improvement of a pencil with an eraser, but somebody might have a patent on a pencil. So I might have to license the right to use his pencil patent, and he might have to, in order to sell pencils with an eraser, and he might have to do the opposite. If he wants to sell pencils with an eraser, he might have to license my patent. So, like I said, it's the right to exclude others. You still need to know whether or not you're infringing somebody else. One of the most important things, and it's something that I talk about at great length with, particularly with startups, is that there are statutory bars to actually getting a patent that could effectively shut down the whole process before you've even started. And what I mean by that is, there are certain disclosures that a person can do accidentally or intentionally without realizing what the ramifications of that are. For example, publicly letting people know what your invention is. So, for example, you write a paper, or you write a blog post, or you go out in public with your invention. That starts in the US a 1-year clock, a 1-year grace period that I'm going to talk about in a second, after which you can no longer get a patent. The same thing goes with sales. If you've invented something and you have a device and you go out and you sell that device, you do one sale on Amazon, that starts a clock, 1 year. You have 1 year to file a patent or some sort of patent application on that invention, after which that invention belongs to the world and anybody can use it. And you could no longer protect it after that. Like I said, it's a grace period, and actually that grace period only exists pretty much in the United States. In the rest of the world, you would already be barred, which means to say, if you write an article about your invention and I think it dropped out. You write an article about your invention and you disclose actually the inner workings. I'm not talking about just the idea, not what it is, but how it works. And you at that moment already can't file a patent anywhere else in the world other than the United States. And people don't realize that, but if the patent office ever finds out that you published something in the US more than a year before, or in other countries even a day before, you won't have a patent anymore. That's how strict this is. So it's something that people, particularly startups, need to be thinking about early on, because by the time you actually get to patenting, it'll be too late. What people can do is file provisional applications. A provisional patent application is basically has all of the information, or it should have all the information that that describes the universe of your invention. So the background of why you needed this invention, what it's about, what it does, why it's better than whatever else was previously out there, what the technical innovation is. That information should be there. It doesn't have to be in the form of a full-blown, no? Yes. Better? No. Maybe it's dying. It's good? No. Hello? No. All right. Well, we'll ditch this. I'll just talk loud. Sorry. Yeah, I'll talk loud. So, a provisional application basically is an informal document that provides all the information about your invention to the patent office, but not with all of the structure and form and technical writing that you need to actually get a patent. And what a provisional application does is it gives you 1 year from the date of filing to convert it essentially to what's called a non-provisional application, a patent application that will be formally examined by the patent office. The advantage of filing a provisional application is it's quick, it's inexpensive, and most importantly, it gets you what's called a priority date. It gets you your earliest filing at the patent office. It never gets seen by anybody unless you end up in a litigation years later, but in which case you may need to prove what you disclosed and how early you disclosed it. But the point is, you get that information to the patent office and it just gets locked away, and you have 1 year to take that and turn it around. They can be very valuable in the sense that, first of all, while it doesn't give you any enforceable rights, you could already write that you're patent pending from the day that you file one, which is good for marketing. It's good for due diligence. It's good to show potential investors that you're taking every effort to protect your invention. And it also, like I said, it gets you a priority date. And what the value of the priority date is that the way that the patent system works is that it's literally a race to the patent office. If I file my invention today and somebody files their invention tomorrow for the same invention, I will win. I will get a patent and they won't. That's how important and critical it is to get your invention to the patent office and filed as soon as possible. So a provisional application is a quick way to do that. Eventually, you do have to turn around and file a non-provisional patent application, which is a full-blown application with all of the bells and whistles that you need. And without getting into too many details, the most important part of a non-provisional patent application, which is a real patent application, is what's called the claims. If any of you have ever seen a patent, or if you haven't, I encourage you to, if you are looking into patenting, grab any patent from anywhere, you turn to the back of the patent and you'll see that it says what is claimed is, and then there'll be a list of numbered claims. Those claims define the scope of your intellectual property. It's what you claim to own within the whole universe of information, right? So if you have a software program that extracts data in a certain way, well, you didn't invent computers, you didn't invent the idea of software, but you've invented a method of extracting data in a particular environment, and that method and that system that does that can be patented. So you need to have that information defined, and the rest of the patent application essentially provides the information in which those claims are understood. So you might reference a crawler or something that, or a piece of script that in the claim that extracts data, and then in the specification, which is the body of the patent, it would explain in detail what that crawler is or what that piece of code is. And obviously a patent attorney can help you with these kinds of things. Patents last 20 years, a maximum of 20 years from your earliest filing date. So not from when it's granted, but when your earliest filing date. That's how they work. I'll just skip through some of these things, but really what can be patented, there are lots of different areas, from software to hardware to physical devices to products, processes, methods of development, really any area of innovation, the patent office wants to know about it, and essentially the government is making this trade-off. You provide your invention to the world in exchange for a limited monopoly of up to 20 years, after which that invention is now belongs to the world. So it's that trade-off, and the alternative to that is trade secrets, which I'll just flip. I'll go back to this, but you could also have design patents that help protect the look and feel of a device, or even of a graphical user interface. I mean, everybody could recognize this. This is actually Apple's patent for the swipe. It's not the functionality, it's just the look of the swipe, which, believe it or not, was enforced against Samsung, and that's why Samsung, which used to have a swipe at the bottom, changed it, and now you just use your finger and drag it somewhere else. But they had to remove that because of this patent. But again, that's about the aesthetic. So there are a lot of different ways of protecting things with patents. The alternative sometimes is trade secrets. Trade secrets are things that are not necessarily patentable. So for example, you have a business method. The classic case from many, many, many years ago was actually a New York case where somebody had a coffee business, and they were roasting beans, and they knew which clients liked their beans roasted a certain way. How, whether it's mild or dark or light and flavored, and somebody from his company took that proprietary information, which couldn't be protected with a patent, and went and started his own competing business selling to the exact same people the exact kind of coffee that they wanted. And he lost because it was trade secret misappropriation. It's basically information that gives you a competitive advantage over other people, and you protect it as a trade secret, and that person comes and takes it. You can't claim to have a trade secret on something that you don't actually keep as a trade secret. So you don't mark it as trade secret. You don't treat it like it's a secret. If you keep your front door open and you tell people about it all the time, it's not going to be considered a trade secret. On the flip side, it doesn't have to be locked in Fort Knox, right? It has to be what people in the ordinary course of business would do to keep their things private. So, having passwords on your computers, indicating which things are confidential, telling people when you meet with them about, in potential business deals, that you're telling them that you're talking to them in confidence, even if they won't sign a non-disclosure agreement, which most investors don't like to do these days because they don't want to get locked in before they even know what it is that they're about to find out about. So these kinds of things can be protected with trade secrets and can actually be enforced in court if need be. I was skipping ahead. Trademarks. Trademarks, like I said, are source identifiers. The whole point of a trademark is to let people know that what they are drinking, eating, the service they're getting, that it actually comes from the company that is claiming to provide it. So when you see the Coca-Cola trademark, which is known as the most famous trademark, one of the most famous trademarks, what's the value of that red and white wording? It's so that you know that it came from the Coca-Cola bottling company and not from some other company. And so if another company named Boca-Cola came along and made the exact same logo with the B, they would be in trouble because they're essentially trying to draw people away and make them think that you are part of that same company. So the whole value of trademarks is exactly to let people know that you are the source of that product or service that's being provided. It's another important thing. It's important to register your trademarks. People start using a name. It's important to start using it right away. You already start to accrue credit from the first time you use it. But if you register it with the with the Patent and Trademark Office, it becomes basically the entire world is put on notice about your trademark. Whereas if you're just using it in your locale, other people in the same industry can be using that trademark in another state or in another region, for example. So important considerations. Finally, copyrights. People think of copyrights when it only comes to books and songs, and obviously those are important because those are original works, and you see all the time lawsuits regarding music being used or videos being used without, that are copyrighted. But actually, in my practice, I find that one of the most important places that people don't think about copyrights is with regard to software, because you could protect your software with copyrights because that is a work, it's an original work. If you file a copyright on the code, for example, of your website, so if your website gets copied, and I'm not talking about, unfortunately, if somebody just sort of looks at yours and makes something similar, that's not copyrightable. But if somebody actually takes your code, the HTML code that builds your website, or breaks into your system, or somehow gets your back-end code, which might not be patentable but may be proprietary in nature, you need to have registered copyrights in order to enforce those copyrights against them. And it also gives you a lot of other advantages in the court, like statutory damages and sometimes treble damages, which is additional damages based on every single use. People do this all the time where they want a website, they look at the back, they look at the code that builds the website, they hit copy and they paste, and then they just make some modifications. And it's literally theft. It's copyright theft. But they people do it all the time. And if you don't have your code registered, there's really nothing you could do about it. It's hard to catch up afterwards. That's pretty much it. If anybody has any questions, I'm happy to take a few questions. I know we're running late, so and I'm available. I'm around all day. We have a booth. You can stop by the Procon booth, and my contact information, and I'll put out cards as well if anybody wants to reach me. So, no problem.